Please be seated. Council ready, we'll hear St. Joe versus Leslie.
Thank you, Your Honor. David Wells and McGuire Woods on behalf of the appellant, the St. Joe Company. The order below certifying a class of 300 owners of 400 properties in a 100-acre tract in Port St. Joe should be reversed. It should be reversed because the trial court abused its discretion in not applying the standards of Rule 1.220B3 and not following the directive of this court in Ernest versus Amico in attempting to envision how the trial of the action would actually unfold so that some objective analysis could be given as to whether or not the class representatives in proving up their claims, or St. Joe in attempting to disprove their claims, would necessarily prove or disprove the claims of the absent class members. There's absolutely nothing in the record below to support that analysis, nor is there anything in the order. Instead, what the court has done effectively is to put aside that analysis in favor of a certified now and let's see what happens later type of approach, which is contrary to Rule 1.220 and certainly contrary to the teachings of this court in Ernest versus Amico. It ignores the rule, it ignores the case law, to frankly the great detriment of St. Joe and great impact on St. Joe. I had 15 of the defendants prepared by St. Joe below, placed into the record as Exhibit 37 below by the plaintiffs, which depicts the tract of land that we're dealing with. And in fact, the area certified is the area bounded by FA 98, as it's set forth here. In so doing, the court ignored highly individual issues. The allegation here is that commencing in the early 1940s and sometime through 1960s, St. Joe filled in low-lying areas of this tract of land with the byproducts of the mill. In particular, this area called the Sock, the low-lying area, was filled allegedly with pine bark, fly ash, and lime grits. And the allegation is that, at least with respect to the fly ash, it can result in contamination of the properties. The first individual issue which the court effectively ignored is there mill waste on these properties? Plaintiffs did nothing to prove up any type of methodology which would allow the class representative to demonstrate that by showing that there was mill waste on the class representative's property, that there was mill waste anywhere. And in fact, the only record evidence is from the FDEP report, which says that there is predominantly pine bark, some lime grits, and some fly ash in the Sock area. The plaintiffs did put on testimony of Mr. Thaddeus Russ, who is one of the class representatives, and in addition, a low-lying area over here on Project Street was filled. So there's no evidence to indicate that there is mill waste in anything other than this area. And importantly, plaintiffs have made a big distinction between the pine bark, shavings off a pine tree, that is used for fill, the fly ash, and the lime grits, stating in their complaint first that the pine bark and the lime grits are much less harmful, and in their brief below, in arguing, pointing out that, well, wait a minute, we're not really reaching everywhere because over here, Millview 3, where the FDEP found there was only pine bark and fly ash, we're not even seeking to have that be part of the class. So one of the individual issues is there mill waste on these properties? And if it is mill waste, is it the pine bark that is supposedly not a problem, or is it the fly ash that is? And there's no methodology to show that if someone, for example, Mr. Russ, does live here in the Sock area, proves that he has mill waste on his property, how does that prove whether one of these properties outside of the Sock has any mill waste on it whatsoever? And it doesn't. And if Mr. Russ can show that, in fact, instead of harmless pine bark on his property, there is some fly ash, and that fly ash is a contaminant. Does that demonstrate it with respect to any other property? Stated another way, if St. Joe comes in and proves up that with respect to Mr. Thaddeus Russ's property on testing that there's no mill waste there, and indeed the FDP report found that in various areas in the Sauk that there is no mill waste. If we come in and prove that up, does that mean that everybody else loses? The answer to that, of course, is no, because you'd have to look at each one of these individually. The court ignores that. The second thing is there contamination? Because the argument here is not that the mere presence of this mill waste is a problem, but that it has resulted in contamination. And there was testimony put on below about arsenic contamination, lead contamination, and vanadium contamination. And one of the reasons that this demonstrative was used below was it took all of the FDEP and all of the plaintiff's experts' findings with respect to arsenic above a certain level to point out the property where, if you assume that the plaintiff is correct and that anything above 0.8 is a problem, what properties would that show if you just used one finding on each property? So each of these beige total properties shown on here are properties where there was a reading of arsenic above 0.8. The remainder that do not have any total on it, there is no such finding, notwithstanding the extensive testing of plaintiff's experts. So if in fact you could show that on a particular parcel of property that there's mill waste and that there's arsenic above a particular level, putting aside whether or not that indeed does rise to the level of contamination or negligence, how does it prove up whether it's anywhere else on the adjacent property or property 3 or 4 blocks over? It simply doesn't prove it up in any fashion whatsoever.
That's just on the soil. Has nothing to do with the groundwater, right?
That's correct, but I'd submit it's not a groundwater case. That's an argument made in the brief below to deal with the fact that there is case law, in particular the Black versus Roy and Polnick case, that says that there's a distinction, a significant distinction between a groundwater or an air emission case and soil case, and that there's at least some science that says that if you have a body of water and you drop a contaminant into it, it will disperse in a certain fashion so that you can measure it. No such testimony was put on below here. The extent of the groundwater discussion is in the FDEP report, where they find little contamination of any groundwater, and one paragraph in Dr. Flowers' report where he merely says what the FDEP does. To give you an example of what you would expect if this was a groundwater case, you could take the Samples case, which actually came up to this court and was affirmed PCA. But there, the plaintiff's testimony was, okay, here is a testimony showing where the groundwater was contaminated, and here's the expert testimony that shows where this plume is. Here are the properties above and adjacent to the plume, and therefore we describe the class in that fashion.
Is there anything in the FDEP report at all having to do with groundwater that somehow correlated to this defined class?
No, Your Honor, there's not. There are some wells that were tested in the area. There was one well that had a finding of lead that, according to the FDEP and the Department of Health report, was likely a problem with the soldering of the pipe, and that there was raised pH in certain of the wells and raised sodium in certain of the wells. And what the Board of Health says is since they're not used for drinking water, there should not be a problem. But no, there's nothing that ties this, no analysis, or certainly no analysis put on by plaintiff's experts, because they didn't opine on it whatsoever, other than the one paragraph that I've referenced, to say that we have shown that there is a plume of groundwater here, as in the Samples case or some of the other cases, groundwater cases, that would allow us to define the class. They've not done that. They've defined this class based upon Dr. Flowers' findings with respect to the soil contamination, but really they've defined the class simply because this happens to be the boundaries of this predominantly African-American neighborhood here that grew up sometime before the mill up until the present time. That's the extent of it. There's no time in this, as you can see, from below to particular levels of contamination, or in particular to mill waste, because here we have the Sauk area and one area on Hodrick Street where there was testimony below. I would submit that if the court were to look at the cases cited, Rule 23 in its advisory comments points out that typically you wouldn't expect to be able to use a Rule 23b3 class in a mass tort type of situation. You could seek declaratory relief, you could seek injunctive relief, but not for damage relief. There have, however, been cases certified. A groundwater plume happens to be one of them. But if you look at the cases relied upon by plaintiff, the Boggs case out of the Southern District of Ohio, the Johnson case out of Louisiana, they're very different. Boggs was uranium contamination. It's a unique constituent. There's absolutely nothing in the record that there's any other way that that could have gotten there. And in fact, the defendants below didn't even contest that yes, there had been emissions, yes, it had dispersed within the area that plaintiffs had defined. All they said, the argument was, it doesn't rise to a level sufficient to cause damages. Well, that's an issue on the merits down the line. It's not an issue as to the definition of the class. And if you can come in and through expert testimony prove up that emissions of radioactivity above a certain amount is enough to get you there, then that will do it. Here, and we don't have a single incident, it's over some 50 years, we don't have unique constituents. Arsenic, vanadium, and lead, the testimony is undisputed out of each of the experts' mouth, appear naturally in background soils and also arise from homeowner activities such as fertilizing, such as the lead paint that was painted on these homes, such as mowing your lawn with a leaded gas lawnmower for a significant period of time would reach the levels that we have here. And there's no dispute below that, in fact, they will do that. So there are ready alternative sources which raise an individual issue for each piece of property. Take the Johnson case, which is a landfill case. There, you had a Superfund site that the city went out and got contractors to come in and supposedly clean up so that you could build homes on it. The issue, the claim was these contractors didn't do their job and therefore they didn't get the contaminants out. There was no issue. As the court pointed out, there's only one source of contamination, period. It came from this landfill. You either got it taken care of or you didn't. And that was a common issue with respect to all of the homeowners. Didn't have a situation where there was an issue as to whether the arsenic in Mr. Russ's home yard, if it existed, and there's no testing there, but if it existed, was from his use of 13-13-13 fertilizer, as the record showed below, which actually has a higher arsenic content than what was found to be objectionable by Dr. Flowers. And similarly, with respect to the lead, the testimony is clear below that, as I said, mowing your lawn or sanding down your house, scraping your house with a lead paint would be sufficient to provide the types of levels that were found. And indeed, class representative Mr. Pittman testified with respect to the lead and with respect to the lawnmower.
Counsel, you're into your rebuttal time, but you wanted to save some time for rebuttal.
I'd like to save some time.
May it please the court, John Mills on behalf of the residents of Millview. First, I'd like to point out the limited scope of this appeal because much has been conceded and much in the order below is not even challenged. All of the prerequisites of a class action, commonality, typicality, numerosity, adequacy of the representation, there's no challenge to that. B3 also requires the threshold determination that a class action would be superior to individual actions. It's a two-prong, that's the second prong, and there's no challenge to that either. Everybody agrees that a class action device would be superior to individual devices if it's otherwise allowed under B3. The only issue in this case is the requirement in B3 that common issues predominate over individual issues. And the standard of review for that is abuse of discretion. So you can reverse only if you conclude that Judge Pittman in Gulf County was completely unreasonable in determining that common issues predominate over individual issues. Now, St. Joe identifies three issues as individual issues in this case. Those are the three only potential individual issues: contamination, causality, and damages. And really they focus most of it on contamination, and that's what we just heard. And so I'd like to focus on that. First off, they complained that the trial court did not engage in the rigorous analysis of going through what a trial would be like, what kind of evidence would be presented to determine if the test is met.
Mr. Mills, let me ask you why the class should be certified as defined when it includes apparently lots that show no contamination problems?
We don't have, that's a key to this case, Your Honor. That's a very good question. We don't have the ability right now to say this lot has contamination, this lot has no contamination. We can say whether a specific soil sample in a specific area has contamination, but we don't have any machine that will tell us, is this whole lot contaminated? So we can take a lot that is contaminated, do a soil sample in one place, and if it's clean, that doesn't mean it's contaminated. If that soil sample is contaminated, then we know at least that part of the lot has contamination. And this is not, we're not alleging a uniform, they just spread it all out over the system. This was a dump. They used it to dump their waste because they didn't have another place to put it, and to fill in the sock area. And there was a suggestion that the sock area is the only place that the mill waste was deposited. Our allegations are it was throughout the class period, and we have evidence to prove that. The key in looking at this chart is this is not a merits hearing. This is not for us to determine, okay, the orange lots are contaminated and the ones that aren't orange are not contaminated. That's a jury question. What we have to look at is the kind of evidence that the class will provide at the trial in this case to ask the jury to conclude that all of the properties are contaminated. We do not intend to prove every lot, to put a sample from every lot at trial, nor do we have to. There's two questions that need to be answered in this regard. First, do we have to prove contamination as to each parcel? And second, if we do, can we do that on a class basis? I would suggest that we don't have to show it for all of our claims. In other words, a claim of diminution in value based on negligence or the statutory strict liability provision does not require actual pollution on your lot. If it's on all the lots right around you, whether you're contaminated or not, your lot is worth less. And that's the first rule of real estate appraisal: location, location, location. But more importantly, even if we have to prove that every lot is contaminated, there are more than one ways to skin a cat. One way would be to do 400 samples and show that at least a portion of each one is contaminated. But as St. Joe alleges, there are other potential grounds for any specific sample to be contaminated. Perhaps it was treated wood. Perhaps it was ant killer. Perhaps it was crabgrass killer. So with each particular sample, there are questions. That's why this case needs to be tried as a class action. Whether it is or not, it will be tried as one. You're supposed to look and see how you try it as a class action, but I would say the flip side is true too, and you should look and see how the individual plaintiffs will prove their cases. Both ways, there are three kinds of evidence that will be offered, and this was all presented to the trial court, and so the suggestion that the trial court didn't consider how the case would be tried is incorrect. First, there's factual testimony from actual witnesses. We have Mr. Russ, who is a class member, a representative, who will testify that he worked at the mill, and yes, they took the waste, everything but the trash, the garbage, and dumped it in the Millview area. So we will have direct testimony of people who were involved that this happened, that waste was distributed throughout this area. Now, Mr. Russ, this happened a while ago. He's not going to be able to testify. We put it on Miss Anthony's lot and Miss Leslie's lot, but we didn't put it on this lot. There's no way he could remember that, and to prove that going back in time would be very difficult. One of the reasons that is difficult is because the defendant did not do anything to account for it, as far as we know, and we haven't received merits discovery yet, but we will argue that they have no evidence that they did anything to keep track of where they put the waste. So any uncertainties in determining exactly where it is their fault, and the jury should take that into consideration in determining whether the standard of proof is met. The key evidence is this evidence, and that is going to be through expert testimony, Dr. Flowers and Mr. Fowler, who have gone throughout the class area and taken samples. We've already seen they've taken a substantial number of samples, and you can see how much of that area is orange. That shows arsenic over the state level. And by the way, the state level is kind of irrelevant because the federal level is 1/2 the state level. And the federal level determines anything over that is dangerous. And the jury's conclusion.
Did Dr. Flowers, in doing his testing, he did some testing of some lots, right?
Correct.
And then he found of those tests that he performed, some of those had problems of arsenic levels beyond what it should be.
That's right.
And on that chart, those are the ones colored in.
Yes, he did not sample every lot.
So did he opine in any way that all of the other lots that are within the class injured by the actions of St. Joe?
Yes, he did, and he opined that it is not limited. He says, every time I go back and take more samples, I find more contamination. And that's the theory that we've put forward.
Well,
that is our evidence.
What was the basis of his opinion, saying that, okay, just on these that I found, and even the ones that showed no levels of arsenic, that I conclude that every lot, every single lot within this class definition has been injured?
Here's the basis, and it's a common sense basis, but it's based in science. And they will have a chance to say that's not a generally accepted scientific principle of extrapolating from sample points. But take that map and imagine it's on a football scoreboard at Doak Campbell Stadium. I'm talking about, it doesn't have to be a football stadium, but a scoreboard where you have LEDs, light emitting diodes that make a picture. You put enough dots together, you can see from the dots what the picture is, even though it's not a photograph. Well, sometimes those diodes burn out, and you don't have all of the diodes, but you can look at that scoreboard and you know what it's a picture of. You know what it says, even though some of the bulbs are out. That is the principle that's at issue here. We can, through sampling, determine whether some of the lights are on or not.
But Dr. Fowers, he did a computer program, correct?
Yes.
And some of his actual testing came below the levels that he predicted in his computer program, didn't it?
No, I don't think that's correct. Again, it's not uniform, so we don't know that just because it's here and not right next door.
But if he predicted a certain level would be found based upon his computer program, his diodes,
right,
and then when he goes out and does the actual testing and it doesn't turn out as the computer program predicted, then doesn't that mean that either we have the wrong picture from the diodes, or you haven't quite met the burden of proving that you have commonality of damages or an ability to prove your damages?
Respectfully, that goes to the burden of proof. It's not, this is our method. And when we put up our method and we go through fraud hearings for our experts and they put up their data, St. Joe's going to get to do the same. And their experts are going to say, well, I tested and your computer model shows there should be contamination here, but there's not. Then you have, assuming everybody passes Fry, you have experts disagreeing. And that's for the jury to resolve. The key point is that this is capable of proof on a generalized basis. Let me give you the flip side, and let's talk about how this would happen if we tried them as individual cases. Let's say we try Mr. Smith's case, and we sample on Mr. Smith's yard, and we find arsenic. And again, there's vanadium, there's lots of other chemicals in this case, but let's just talk about arsenic. We find arsenic. So we put on behalf of Mr. Smith, evidence that there's arsenic. St. Joe comes and says, well, wait, Mr. Smith used weed killer that contains arsenic, so that might be an explanation for it, so you haven't proven anything. Well, the next logical step is, well, Mr. Jones is the next door neighbor, and we sampled him too, and he's got arsenic, and by golly, we can prove that he never used crabgrass killer. Well, St. Joe's going to say, he didn't use crabgrass killer, but he used pressure-treated wood. That contains arsenic. Okay, well, let's go to Miss Meyer's lot next door, abutting all three of them. She's got the same level of arsenic. She doesn't have pressure-treated wood. She doesn't have these other things, but she still has the arsenic. And you keep getting bigger and bigger until you show the whole area where you know there was dumping done. That's what we've got here.
But my problem is we've got places there that are fairly large, it seems to me, with no coloration on here. There's no problem indicated here, so my concern is an overbroad class. Don't we have an overbroad definition of a class here?
No, Your Honor. First off, there's no argument that the class definition is overbroad. They just say you can't have a class. So the appellants haven't said you can have a class, but it has to be smaller. It has to be the sock, for example, only. So that's not an issue unless the court...
Well, I mean, they can defend and say that your class is inappropriate. They can defend and say that's not an appropriate class. They don't have to tell you how to define your class.
Oh, they can, but they haven't. That's not their argument. That is an available argument to
any defendant. They haven't argued that this is not a class?
Their argument is it's not a class, period.
Right.
That common issues predominate over individual issues.
Right,
not
you picked
that
out a group of people.
Picture.
Right, you picked out a group of people, and they're saying common issues do not predominate in that group of people. Now, you might be able to pick out another group of people, I don't know, where they wouldn't be able to make that argument. But they don't have to sit and define your group for you, do they?
Well, these are questions of evidentiary sufficiency. And the trial judge, looked at these and determined that we've shown a method of proving it. She didn't determine we proved it. Nobody's to determine whether we win the case or not. This is just whether it proceeds as a class action. And she was presented with a means where you can extrapolate. And that's what the experts do. That's what Dr. Fowler does, is he extrapolates based on samples. Now, they can move for summary judgment and say, you haven't presented enough samples. There's too much blank spot, as Judge Colston just said. Or they can do it on the Fry hearing. If their expert can say, that's not enough sampling to be generally accepted to prove that.
But they can't say that's not enough sampling to be certified as a class?
No, they cannot. We have demonstrated.
If you did half that sampling, could you still have your class?
Yes.
And a quarter of that sampling, you could still have your class?
I think so, yes. I think at some point you have to show.
So in reality, you could go out and sample one parcel of land, find arsenic, and say, we know that they dumped mill waste in this general area. We don't know exactly where.
You couldn't do that if that were your only evidence. And
So
thankfully,
two parcels. With two parcels, you could.
If you had two parcels and you had testimony from somebody that says the mill waste was dumped all over these properties, yes, I think that would be sufficient. We've got more than that, but yes, I think we're not relying just on science here. We're relying on direct testimony of witnesses who said, I spread the stuff around. So we know it happened. The question is just where it happened. And we have a methodology to determine. You're never going to be able to determine with any certainty. So the question is whether these people can proceed or not. And again, in an individual basis, for Mr. Smith to prove his claim, he's got to show everybody around him is contaminated too. Because as you saw from their initial brief, one of their big defenses is, well, any particular individual, contamination could come from lots of household sources. And it's only by taking a bigger picture where you take those individual variables out that you can get a scientific view of where the pollution is. That's what we're doing. And for an individual case to proceed, there's 424 parcels. In each of the 424 cases, to overcome that defense, that's the evidence they're going to have to put on. Pollution does not know lot lines. These lot lines were not in place. St. Joe didn't say, well, let's put it on this property but not this property. They're artificial lines that the government plotted down at another point.
Yeah, but they could, and if they've got dump trucks going out there, they could have had certain areas that they dumped pine bark, certain areas that they did the more harmful ash. So, I mean, it's perfectly conceivable to me that the ash is going to be only on certain lots, not this whole defined class.
Right, but we can't get that discovery. We can't get class discovery until it's certified. That's the law.
So it seems to me the dirt, the soil here is more lot specific, perhaps, than if you were talking about groundwater, where obviously that goes and disperses out through the rest of everybody's lots underneath the ground. But
Sure.
I don't see where in the certification there was much dwelling upon that. They take on in the
Well, let me show you where it is, because they're just wrong. It's all over the case. In the complaint, paragraphs 31, 34, 37, and 38 allege groundwater contamination. In the motion to certify the class, pages 8 and 10 focus on groundwater contamination.
Well,
I'm out of time.
Yes, go ahead.
Let me try to focus you more closely in on expert testimony. They say there is none.
Well, no, they don't say there is none. They say, well, there's none except for Dr. Flowers' testimony. And yes, his report says there's groundwater. NDEP says there's groundwater contamination. They say, well, that's just some contamination. Yes, but it is contamination. So there is some evidence. And more importantly, this is not summary judgment, and it's certainly not a trial. We don't have to come up with all our expert evidence showing how much groundwater we know. We just have to allege it, show we have a basis in fact for it, we have, and that it's something susceptible of proof on a class basis. I've got lots more to say, but I'm afraid I'm out of time.
We'll give you a couple more minutes because we'll just add some additional time on the other side.
Thank you very much. I appreciate that. Let me just go over. This is what every trial will involve. These are the common issues. Causation is a common issue. There's joint and several liability. The statute specifically says where there's pollution, you don't apportion liability. So whether there's other sources of pollution or not does not matter. If we prove contamination, all we have to do is prove that that contamination affects market value and affects the need for remediation. That's the causation, and that is purely common. All the issues of law are common in this case. Whether actual contamination must be proven under each theory. The Bouchard case they cited says a business, when there's an oil spill off the coast, a business not directly impacted by the oil spill may have a cause of action For lost business, it can't proceed on that on a class action basis because you have to prove lost business on each individual case, but they recognize that that could be a claim. Whether St. Joe owed a duty not to pollute Millview, whether it owed a duty to disclose pollution after it learned it was hazardous, whether there's strict liability under the common law or Section 376-313, whether comparative negligence applies, as we just said, that's their third and fourth affirmative defenses, whether the fact that pollution occurred before the property owners acquired the property and where there's no privity, whether that defeats recovery. That's their seventh affirmative defense.
So then
those are all common issues of law.
Then you would say that the judge erred when she excluded the business properties from the class, correct?
No, I'm not.
Well, I mean, did she?
She did.
I mean, that would be because business properties would have the same issues that you just named, correct?
They would have much of the same issues, but the valuation issue would be different because the valuation of businesses on 98 are going to be based more on their proximity to 98 and their income than on the fact they're back in this neighborhood. So I don't think she erred. I mean, we would have liked to have that in the class, but I don't think that's an error. Here are the fact questions that are going to have to be tried in every case. And this is a week's worth of testimony in every case. The history of St. Joe's Power Mill, the wastes that are generated by the mill. You can see from the brief and the reports down below that there's a lot of sources. What happens is they burn things to generate steam to run the plant. What do they burn? Anything they get their hands on. Paint, hazardous wastes, other things. What's left is ash that can't be reburned, it can't be reused, that has arsenic, lead, vanadium, mercury, cadmium, nickel, PAHs, PCBs. We've got to get scientific evidence to show all of that, and we've got to get a mill expert to say this is what mills produce. Then we have to show scientific expert testimony of what the health risks are for each toxin, why that's bad. Then we have to put on evidence of what St. Joe's method of disposing of its waste over time was. Did they treat it? Did they put it somewhere safe? Or did they, as we allege, put it on Millview? We have to go over the costs of alternative methods of disposing. How much money did St. Joe save? That's our unjust enrichment claim. They saved money by not dumping it where it's supposed to go. Their intent, we have intentional torts here. We have to prove St. Joe's knowledge of presence of hazardous materials, risks to the community. Every class member, if they have to proceed individually, will have to understand and present Florida DEP assessments in the area and the discovery of contamination. It was not discovered until around 2000. You've got individual statute of limitations questions, but they're all based on when you should have known. And so when you should have known is another common question based on these DEP reports. St. Joe's efforts to assess and remediate pollution disclosed by the government investigation. Then we go to the Millview neighborhood itself, the history of the neighborhood, how it came to be there on this dumping ground. Then there's the science of the area, the geology and the hydrology, the contours, the sand dunes, the wetlands that were filled in, the surface waters that were not there that are there now. How humans can be exposed to these chemicals that are in the dirt. If they're deep below the dirt, is that really a risk? Can they migrate? Ants. We got to talk about ants. These studies of ant piles show that the ants are digging up toxins that are 6 feet under.
Excuse me, Mr. Mills, we've given an additional 5 minutes, and I think we've gone a little bit beyond what's necessary to address the class certification at this point. So if you just bring that to a close, we'll extend an additional 5 minutes to the other side in rebuttal.
I appreciate the time, and I ask that you affirm.
You have about 7 minutes.
The appellee's argument as to how this case would be tried absolutely and unequivocally demonstrates why it can't be certified as a class. The arguments we heard were, well, we would have to, property by property, look to see if there's contamination on that property. And if there's contamination, where it came from, what are the alternative reasons for that? Property by property. The concept of a class action is that the class representative, by proving up the elements of his claim, by Mr. Russ proving up that my property was contaminated, it was contaminated by St. Joe, and here are my damages, will prove up the claims for each and every property member. What we just heard is that's not the way this case will proceed. This case will proceed lot by lot, going through on a lot-by-lot basis to determine, is there a mill waste? Did that mill waste result in contamination? Is there any contamination at all? And if there's contamination, was that caused by the resident or actually the resident's predecessor over some 50 years? That is lot by lot, property by property. There's nothing in 376 that changes that analysis. All that strict liability statute does is with respect to that one cause of action, flip the burden, which says if plaintiff can come in and prove that this property right here, that the testing already shows is not contaminated, but if they can come in and prove that that property was contaminated, then the burden shifts to St. Joe to show that it's not contaminated. We have the absolute due process right to come in with respect to this property and put on testimony for this jury to review to determine, in fact, that it may be contaminated, but there's no mill waste on it, and it wasn't contaminated by mill waste. What we can show you is, I use a better example, the La Chira property up here. There's no mill waste on this former elementary school site, and that the contamination is because the owner, Mr. Leslie, when he built it, decided to use dolomite for the parking area. Line, which has been tested in this case, shown to have 7 parts per million of arsenic, well above the level that Dr. Flowers opined was a problem.
But, Mr. Well, let me get you to address Mr. Mills' position, which I understand is Dr. Flowers, he says, has put on an opinion through expert testimony that the defined class has contamination, every lot has contamination in its soil and groundwater. And he has opined that all those lots have that contamination, and it's been harmed by St. Joe, and St. Joe didn't put on its own experts, didn't come in with proof before the evidentiary hearing before the trial judge for the class certification. So it's would abuse of discretion standard. We ought to take the trial judge's determination of the class certification and affirm. So how do you respond to that?
It's an absolutely incorrect description of Dr. Flowers' testimony. Dr. Flowers does not testify that the entire area is in fact contaminated. Indeed, Dr. Flowers prepared contour maps where he attempted to depict, and I think Judge Hawks pointed up on that, attempted to predict where there would be contamination based on there was shown contamination. Even those contours don't cover the entire area, which he admitted. More importantly, he admitted, and this is at page 231 of his testimony, and is it correct that there are areas where this contour program is predicting the arsenic concentration to be in excess of what your own sample revealed at that location? Yes, that in fact the predictions that he's making aren't correct. But the important point, I think, for the class certification is, all right, how does that play out at trial? Because the issue before the judge, it wasn't appropriate, and it wouldn't have been appropriate for St. Joe to come in and argue the merits. This is contamination and this is not contamination. The argument was supposed to focus on, as this court has directed in earnest, how will the case get tried? And is there a way that you can prove it up by proving it up as a representative plaintiffs? So our testimony was, can you come in and by simply testing representative areas determine that there's contamination for the entire area?
He said they just did.
I'm sorry?
My understanding is Dr. Flowers put the testimony on. He has an opinion that, yes, every lot in here is contaminated. Its soil and groundwater is contaminated, and St. Joe's responsible.
And I can only direct the court to the record to review Dr. Flowers' testimony as cross-examination, because that most certainly is not a fair analysis of what Dr. Flowers has done.
There's no testimony like that. There's no opinion by Dr. Flowers to that effect.
That's correct.
Okay.
No, his opinion is he identified areas that were in fact contaminated. He predicted additional areas, which still does not cover the entire area with respect to that. And the testimony, I think, is unequivocal, undisputed, that you have to be able to go in there and testify, or test, lot by lot to determine whether, in fact, there's, number one, any mill waste there, number two, any contamination, and what the cause of the contamination is. Envision what this trial is going to be. We just heard that testimony. We're going to be sitting there in a class action where presumably the jury's verdict comes back with respect to each of the individual class representatives, and yet it's going to be binding with respect to all of the other properties. That means one of two things happens. Either we're denied our due process rights to defend on a property by property basis, or it devolves and becomes a property by property analysis, and that is not what the class action is supposed to be for, the class action is supposed to proceed. One of the problems with the record below is plaintiffs wholly ignored the concept of coming in and show us the methodology as to how you're going to demonstrate on a representative basis that there's contamination and the contamination was caused by St. Joe. We demonstrated that they can't. It comes in on a lot-by-lot basis. The appellate court's order, the trial court's order doesn't do what this court has directed, and that there's no indication of how the case will proceed forward, no basis for a meaningful evaluation of, okay, how would this case end up? What it does instead is to put in bold font at page 14 that should the trier of fact or the court, based on a dispositive ruling, subsequently find that any portion of this class is not legally entitled to the relief, they get knocked out. So basically what that means is you go through, you try the entire thing as if it's individual by individual, and the jury presumably takes them out one piece at a time. How is that going to happen? We're going to have a 1.5 year long trial here with respect to that? This has to proceed forward on an individual basis. The very arguments that plaintiff has made with respect to Chapter 376 indicates that these individuals can bring it. They can get attorney's fees. They can recover their damages, which are substantial here. There's simply been no showing below, in accordance with this court's directive, that, in fact, this can proceed forward on anything but a lot-by-lot basis. That's not how a class action works.
Thank you very much, counsel. That concludes our cases for the afternoon. We'll be in recess until tomorrow.